Hi, everyone, and welcome to the third webinar in the GGO March webinar series. My name is Augusta Van Mayen, and I'm a member of the Grape Growers of Ontario Next Gen Committee. I currently hold the position of Vineyard Manager at Taws Winery in Niagara. Please feel free to enter any questions you may have in the Zoom question and answer section throughout the presentation. Kira White, the GGO system administrator, will be moderating the questions, and there will be a dedicated time at the end of the presentation when the presenter will answer them. The webinar series is part of an Employment Ontario project funded in part by the Government of Canada and the Government of Ontario. We thank them for their support and thank you for joining us. I'll provide a brief description of the Next Gen Committee and then introduce you to our speaker. The Grape Growers of Ontario Next Gen Committee is a collective group of grape and wine industry partners empowering the next generation to create a unique and thriving grape and wine industry that dominates the global stage. We advocate on behalf of the next generation of grape growers and winery stakeholders to foster sustainable growth and success. Our goals and activities focus on promoting agriculture, education, and careers, attending trade shows and events on behalf of the GGO, attending key government relation events, and telling real farming stories that build community and interest in Ontario grape farming. Today, we are joined by Erica Blythe, who is presenting on legal considerations to establish and grow your vineyard business. Erica grew up on a fourth-generation grape and fruit farm in the town of Niagara-on-the-Lake. Erica was called to the bar in June 2020 and is now an associate at the Martin Shepherd Fraser team, where she is practicing wills and estate law, corporate and commercial law, and real estate law. Welcome, Erica.
Thank you, Augusta. Good afternoon. Thank you to Kira and the Grape Growers of Ontario for inviting me to speak today at this year's webinar series about the legal considerations of establishing and growing your business. As Augusta mentioned, my name is Erica Blythe and my maiden name is Erica Vandelar. So some of you may know my father, Chris Vandelar, who was a 2018 to 2019 Grape King. And some of you may know my husband, Philip Blythe, who is now actively involved in my family's farm. Philip Blythe is also a member of the Next Gen Committee. I was called to the Ontario Bar in June 2020 at the height of COVID. I graduated from Western University with an honors business degree and subsequently from Western Law with a law degree. I practiced family law at a boutique firm outside of Niagara and returned to Niagara in 2021, where I joined Martin Shepherd Fraser and am now a real estate, wills and estates, corporate commercial, and family law lawyer. My goal for today over the next half hour is, other than trying not to bore you to death, is to discuss the legal considerations for new farmers when growing your business, when establishing your business, or growing your family's legacy. As a disclaimer, please remember that when you ask a lawyer a question, the answer is invariably going to be, it depends. I am going to scratch the surface of the legal principles and legal considerations for new farmers, but please do not take everything I say as gospel, because the answer to your specific question will truly depend on the specific facts of your specific case. I'm going to leave my contact information at the end and will be happy to answer any general questions at the end of the presentation. If you have any specific questions, I will be happy to discuss those offline at a future date. So whether you are a new farmer starting from the ground up or a fifth generation farmer working towards an ownership interest, it's important to turn your mind to your business and estate plan. I'm not telling you to think about your business and estate plan for selfish reasons, but rather I'm encouraging you to consider the adverse consequences when your business partner unexpectedly dies, or when you experience a marital breakup, or when your landlord or tenant's estate denies that you have had a verbal handshake agreement for many years, or worse, when you die without a will and your hard-earned money goes to someone who you had no intention of receiving a benefit. So although putting everything into writing will cost some money upfront and will definitely, there will definitely be a time commitment. I can guarantee that the financial and time commitment that you invest at the outset will save you, your family, and your estate a lot of money, time, and stress in the future. Are you in an employment relationship? I bet many of you are in some type of employment relationship, whether you are an employer or employee. If your family hires staff to work full-time, such as at a winery or store, or part-time, such as at a seasonal market, it is important to consider having a written employment contract. Although in Ontario, it is not mandatory that you have a written employment contract, it is highly recommended, especially from an employer's perspective. There are two things for an employment contract to be legally binding and enforceable in Ontario. First, there must be consideration, which in most cases is the job itself. If you have an existing employee and you now want them to sign an employment contract, consideration could be a raise, a signing bonus, or extra vacation. And second, it must comply with the minimum standards outlined in the employment statute, which in Ontario is the Employment Standards Act. Having a written employment contract allows parties to crystallize their expectations in the fundamental terms of their relationship, such as salary, wages, bonus, benefits, hours of work, and most importantly, and most litigated, is the entitlement upon termination. In the absence of an employment contract, if an employee is terminated without cause, they will be entitled to common law damages. This is the notice or pay in lieu of notice that a court determines an employer ought to have provided to the terminated employee. Depending on the circumstances, this could be anywhere from 24 to 36 months. Whereas if you have a written employment contract, you are able to limit that entitlement to the minimum standards set out in the legislation, which currently is a maximum of 8 weeks. So as you can see, this could be a difference between a maximum of 24 to 36 months versus having an employment contract and having a maximum of 8 weeks. Additionally, if you do have an employment contract, it's important to review it regularly to ensure that it is up to date and reflects the current circumstances of your relationship. You will also want to consider checking in with your lawyer regularly to ensure that the provisions in your contract do not contravene the provincial legislation. And next slide. If you're leasing vines, trees, land, or your home and do not have a written lease, now is the time to consider one. If you have been operating for many years based on a verbal handshake agreement between a landlord or tenant, it is critical to remember that the handshake deal is only as good as the word of the person who entered into it. This means that you cannot and should not rely on your spouse, child, or estate trustee to enforce such an agreement, as it is likely not legally binding. In addition, according to the Statute of Frauds in Ontario, any lease or transfer of land must be in writing. There are also Planning Act considerations. If you lease a portion of a landlord's land for a period extending beyond 21 years without obtaining the appropriate consents from the municipality, it is likely that that lease is void. Any agreement, like any lease or transfer of land that contravenes the Planning Act in Ontario, is of no force in effect. In the absence of a written lease, should a dispute arise between the parties, it will be very difficult to ascertain the intentions of the parties, and therefore likely to result in litigation and significant legal fees for both parties. A properly drafted lease allows you to ascertain the intentions of both parties, outline the fundamental terms, provide protections for the landlord, especially where environmental liability could be a factor, and provides a useful guide for the heirs if the landlord or tenant unexpectedly dies. So why do you need a lease? There are two types of farm leases that are most common in Ontario. The farm land lease, which most of you are probably familiar and comfortable with. This is a price per acre lease, and the other is a crop sharing agreement. So the farm land lease will vary significantly depending on the type of farm and the size of the farm and any municipal restrictions or laws applicable. So points of similarity that are going to be present in almost every lease include the description of land to be rented, and it's important to be as specific as possible. The rent payable, the term of the lease, and any renewal options that the tenant has. The use of the land. So as a landlord, remember that you bear the ultimate liability. It's important that you know and you outline exactly what the tenant is going to be doing on your land. So whether that's pick your own fruit or whether they're just growing cash crop, it's important that you outline these terms in your lease. And this will also determine insurance requirements. You want to outline what types of insurance is required and to which party will be paying the premiums. Any restrictions, so any restrictions that you might impose as a landlord, or more importantly, any restrictive covenants that are registered to title and run with the land should be clearly outlined in the lease as well. So those are the fundamental terms, and then there could also be optional terms, especially for tenants who have strong bargaining power. These can include an option to purchase the landlord's land within a certain period of time, a right of first refusal, which could be also registered to title, and addressing what will happen upon the sale of the land by the landlord. So whether you intend that this lease will be binding on successor landlords, or whether the lease will be terminated upon a sale, and you might want to include any early termination provisions for either party. It's important to be as thorough as possible and not to leave anything open for interpretation. Although you might have an understanding with the other party at the time, things could break down or go sideways in the future. And if the dispute arises and this lease ever goes before a judge or a mediator, they aren't going to be privy to that mutual understanding, and they're only going to read what's in your lease agreement. So be as thorough as possible. And then the other common type of lease for farmers is a crop share agreement. This is a relationship between a landlord or a landowner and a farmer. And in this type of relationship, the landowner and farmer work much closer together than in a farmland lease. The landowner will give its land and the farmer will provide its work. In this relationship, the landowner and farmer share the risks and rewards of farming. So they share generally everything from the cost of fertilizer to the revenues of the crops. This could be anywhere from a 50-50 split of revenue to a 35-65 split, depending on the negotiation and the terms of the agreement. And then the next slide. So if you're in a corporate, if you are a shareholder and own shares in a privately held corporation, or you're a partner in a partnership, it's important to consider a shareholder or partnership agreement. Shareholder agreements are critical when there are 2 or more shareholders. And likewise, partnership agreements are important whenever there are 2 or more partners. Oftentimes, privately held corporations or partnerships consist of immediate family members, and people often think that these agreements are not necessary because it's immediate family. I would counter that, and I would argue that these agreements are most important when the parties are immediate family. And the reason is because, unfortunately, disputes between family members arise much more often than we would like to think, between children upon the death of their parents, or between grandchildren upon the death of grandparents. So partnership and shareholder agreements can set out what will happen in the event of the death or incapacity of one of the shareholders or partners, and can also address what will happen if a partner or shareholder wishes to leave the business. And again, although things might seem great at the outset, these agreements become essential in the event of the sudden unexpected death of a partner, a marital breakup for yourself, or a marital breakup of one of your partners. And unfortunately, that former spouse could make a claim against the property of the business. So it's important to draft these agreements in the event that a dispute arises, because again, in the absence of an agreement, it will be very difficult to ascertain the terms and the intentions of the parties. So these agreements can be used as evidence in the future, and more importantly, they can be incorporated into your will as again, a guide for your heirs if you unexpectedly pass away. So speaking of marital breakups, it's important to consider a cohabitation or marriage contract. Many people think that these agreements are taboo because people think that they are essentially planning for your marriage or relationship to end before it even starts. I've seen a lot more of these agreements now as people are getting married or entering into serious relationships later on in life. If party A enters into a marriage with a successful income generating business, and party B enters into the same marriage or relationship armed with student and credit card debt, party A is probably going to want to protect their assets regardless of how much they love the other person. As I tell clients and prospective clients, it's always better to discuss asset distribution and other various issues when your relationship is in a good place and both parties are able to have a rational discussion and think clearly rather than arguing about it when it's too late. Like I tell clients, it's always better to hope for the best, but plan for the worst. So just as an example, if you inherit a significant amount of money or property from your parents or grandparents, either during their lifetime or upon their death, and you begin living in that property with your spouse, or you invest that money into the acquisition of a home or maintenance of the home, it is likely that upon your death or the breakdown of your relationship, your spouse will have a claim to that money, that gift or inheritance, in the absence of a well-drafted cohabitation or marriage contract. And then arguably the most important consideration when making your estate plan is, of course, making your will. So the first thing I tell people and prospective clients is that you're never too young to start thinking and making your will. You should begin, I tell people to begin thinking or making their will when they have accumulated at least $50,000. And the reason for that specific number is because currently in Ontario, probate or estate administration tax is calculated on the value of your estate over $50,000. When you have a child, you want to make sure that you've made appropriate plans for that child. When you own property, or probably when you get married or you're in a serious relationship. If you die in Ontario without a will, your estate will be governed by the intestacy laws, which is the Succession Law Reform Act. This means that your estate could go to people that you had no intention of providing a benefit, because in the legislation, there's an order of beneficiaries based on kinship. So this legislation, of course, does not take into account your wishes or your intentions. Additionally, if someone wants to be your estate trustee and administer and eventually distribute your estate, they'll have to make a court application to be your estate trustee. And this will, of course, delay the eventual distribution of your estate. The cost will be paid out of your estate, so it will effectively decrease the value of your estate. And it will take a lot of time and probably cause a lot of stress for your loved ones that you leave behind. So the most important consideration when you draft your will, of course, is that you can choose the people that you want to benefit and to administer your estate. So naming your estate trustees is the first thing you'll want to consider. This is a significant task that requires a lot of time and responsibility, especially if you have minor children or trust within your will. It could last for several years. So you want to make sure that you're naming people that you trust, who you believe will act in your best interests and the best interests of your estate and ultimate beneficiaries. You also want to consider naming alternates in case the persons that you choose initially are unable or unwilling to act due to death, incapacity, or otherwise. Another important consideration is, of course, naming your beneficiaries. So naming the people that you want to eventually benefit from your estate. And then, of course, naming alternates in case the people you choose at the outset predecease you. If you have minor children or minors that you intend to provide a benefit to, there it's important to note that they are not able to receive a significant amount of money until they're 18. So their money will be held in trust until they're 18 or such older age that you may determine. So for some people that could be 21, 25, 30, it's really up to you. And then it's important again to name alternates in case the minor unfortunately predeceases you or dies before attaining the age specified in your will. If you have any beneficiaries who have special needs, it's important to make appropriate accommodations for them within your will. So a Henson trust will ensure that their inheritance does not disqualify them from receiving government benefits such as ODSP. And then most importantly, for a lot of people who have children is the naming of guardians. And then again, alternate guardians in case the first are not able to act. Although naming a guardian in your will is not going to be binding on the court because the person you name now might not be the most appropriate person 5, 10, 15, or 20 years down the road. So the person that you name will have de facto custody of the child, and they will have to go to court and still make an application to be the legal custodian. However, the naming of such a guardian in your will be strong evidence when the court determines the best interest of the child, and is something that the courts will heavily consider when making the determination. And lastly, if you have estate trustees outside of Canada, you'll want to discuss this with your lawyer or with your accountant because this could have adverse tax consequences for your estate. Now, when you have a will, it's important that you update your will regularly. I recommend to people to review their will every 5 years, and especially when an important or significant life event happens. For example, the birth of a child or grandchild, marriage to a new spouse, or separation from a spouse, or the start of a new business venture. Although in Ontario, it's not mandatory that you ever update your will, of course, it will continue to be valid. I've seen in my professional and personal life that many wills in family and from clients are 20, 30, 40 years old. And unfortunately, the people named in the will are estranged or have died or lack capacity. So it becomes very difficult for the estate trustee to either try and locate those people, or it can turn into an intestate estate, even though that probably wasn't your intention. And then another thing to consider if you are a shareholder in a privately held corporation is to have a secondary or corporate will. This is a will that will govern your assets that can be transferred without probate or certificate of appointment of estate trustee. So your primary will is going to govern all assets that may require probate or estate administration tax, such as real estate and bank accounts. And then your secondary will governs things that can be transferred without probate or estate administration tax, such as collectible items, or shares in a privately held corporation. Although there is an upfront cost, of course, to having a secondary or corporate will, it will save your estate a significant amount of money, especially if your business is successful and your shares are significant in value, because this can save a lot of probate by decreasing the value of your estate. And then last, of course, when you're thinking about your will, it's important that you don't forget about your powers of attorney. So powers of attorney, again, are not mandatory in Ontario, but it is highly recommended that you prepare them. A power of attorney is a legal document that allows you to appoint a person referred to as your attorney to act on your behalf. In the case of a continuing power of attorney for property, they will be able to have the authority to manage your assets and your real and personal property. And your power of attorney for personal care allows you to appoint a person to act and make personal care decisions for you when you're no longer able to do so. Now, again, the person that you appoint is referred to as your attorney, not to be confused with reference to your lawyer. Your continuing power of attorney comes into effect as soon as it's signed, unless the document states otherwise. This document gives your attorney significant power. They can do essentially anything that you can do except make or change your will. So it's important to name someone that you trust, who you know is going to act in the best interest for you, because of course they have a lot of power. If, for example, you're unable to go to the bank or go to the lawyer's office when your house is closing, they can take that document and they can go and do those things for you. And this document continues to be valid even if and when you become incapable, hence the term continuing power of attorney for property. Your power of attorney for personal care is a little bit different. It only comes into effect when you're incapable of making medical decisions for yourself. This allows a person or persons that you choose to make decisions such as giving or refusing consent to certain treatments, hygiene, shelter, your clothing, and your safety. And only, again, when you're incapable of making those decisions. And within this document, you can also include some directives. So you can state whether you wish to have extraordinary measures such as life support, or whether you wish to be an organ donor, and other things, such as whether or not you want to be in a nursing home, and if you have any specific requests. These are, of course, not going to be legally binding, but this is a way to express your wishes. And again, similar to naming of your executor within your will, it's important to name alternates in case the first named are unable or unwilling to act for various reasons. All right, so if you don't make a power of attorneys, it can have significant consequences for and lead to stress for your loved ones if you were to become incapable of managing your property. The court in this case would appoint a guardian of property, and the difference between a guardian and an attorney is that an attorney and your power of attorney is someone that you choose for yourself at a time when you're capable of making that decision, whereas the guardian is a person that's going to be chosen by the court or the Ontario Public Guardian and Trustee to act for you when you're incapable of making a decision for yourself. So again, this will create time delays, and this will cause a lot of money from which you will ultimately be paying, and it will cause a lot of stress for your loved ones. Having a power of attorney for personal care creates some clarity in terms of who is responsible for making certain decisions, and also what course of action is to be taken. As most of you probably know or can imagine, when these documents, especially power of attorney for personal care, needs to be used, emotions can be heightened, and family members might not be able to think clearly or rationally. So having this document in place and having your wishes written down can avoid a lot of potential disputes between family members. So when making your estate plan and business plan, it's important to consult and speak to your family and friends. But most importantly, it's important to speak to your lawyer and in many cases, your accountant to ensure that your wishes are properly reflected and eventually carried out. So as a final remark, as I said at the beginning, these agreements and the process of making your business plan and estate plan is going to involve a time and financial commitment at the outset, but I can almost guarantee that it will pay off in the long run. It will save you, your family, and your state a lot of time, expense, and stress in the future, and your family will thank you in the end. Thank you. And my contact information is on the slide. So if you have any specific questions or would like to discuss any of this further, please contact me and I'd be happy to do so. And I'm happy to answer any general questions at this point.
There are 2 questions that came up in the chat.
Okay.
The first one is, with a right of first refusal in a lease, can the landowner enter into a into a bidding war between the tenant and the potential buyer? That is, can the owner go back and forth between the tenant that has the right of first refusal and the potential buyer to get a higher price after the initial offer?
So I think that really depends on the wording of how it's written in the lease and how it's written when it's registered to title. Generally, a lot of those types of clauses will state that the obligation will be on the landlord to present the tenant with the offer. And if the tenant does not accept that offer on the same terms and conditions, so the price and any conditions that were in the offer, then the landlord is generally able to just go with the purchaser. So it's generally not like intended to create a bidding war between the tenant and the purchaser. But again, it really depends on the wording and how the clause is written.
Mm-hmm. And the second question is, if the power of attorney for personal care does not specify do not resuscitate wishes, will my attorney be able to make that decision? Is it harder for them to get doctors to follow direction if I do not specify in my power of attorney?
So in your power of attorney for personal care, we generally, well, I think every lawyer is different how they will write that. We generally don't put a DNR in there. We don't go to that extent. What we would put is no extraordinary measures clause, which essentially means that you don't want life support, you don't want to be kept on life-saving measures for an extended period of time if the doctors determine that there's no hope. So I think having that kind of clause will be strong evidence, but in terms of having specifically a DNR, that's something that typically you would discuss with the doctor prior to going into a surgery or prior to being hospitalized if you're capable. Absent that, yes, the attorney that you name is the person who will have the decision-making power.
I know that, I mean, that was a lot even for me to take in. I was like, oh, this is intense. And I mean, that is something that is very true about this side of business, is it can be quite overwhelming, even personal, like powers of attorney and things like that. I mean, it does feel like a lot to take in. Do you have suggestions of how to ease into it? Is it best to reach out to someone like yourself and just have that initial conversation?
100%. I know I discussed a lot and probably what will constitute your entire estate plan. You don't need all these documents, but I wouldn't recommend sitting down and today and doing it all at once for sure. If you want to speak to myself or your accountant, I think going through and just having a conversation about what you need, your situation, then I think that professional would be able to better guide you and say, hey, I think you really need a lease, or hey, I think you really need to consider a shareholder agreement, and then incorporating that into a will. And that's something that we could do over like a couple weeks or over a couple months. It's not, I don't want you to panic and think that you need all these different agreements, a marriage contract, a shareholder agreement all at once, because that's going to make you definitely overwhelmed. But yes, definitely reach out to me, reach out to the person that you're most comfortable working with, and we can just have a conversation about where to begin.
Well, and like you said at the very beginning, it all depends on your organization too, right? Your
Exactly.
company, your structure, everything. Like everybody's situation will be different. Absolutely.
Exactly.
Another question I had actually was, is there a certain size of employee pool that you should start having employee contracts? Like, is it 5, 10, or is it 1? Like, should you always have an employment contract with whoever you have employed?
I would say it's from an employer's perspective, I think it's always a good idea to have something. It doesn't need to be necessarily, if you have a small, like, fruit market, for as an example, and you only employ like 5 summer employees, you don't need to have a 20-30 page agreement, but I think just having something that, even just to confirm the basic terms, like the wage, entitlement on termination, like hours of work, I think that's beneficial, even if you only have 2 to 3 employees.
And finding, like, for a template for an
Mhm.
employment contract, is that something that someone like you could provide, or can they just Google it? Is there anything that would be, like, in terms of resources, helpful for them to find online, or anything that they could use as a
Yeah,
jumping off point?
yeah, like, of course, if you're looking to save money, and you can always look online, but I always caution people who try to make wills using online templates or any type of lease agreements. Like, number one, if you don't know exactly like what blogs are good and reliable, you could end up with something that's not even in compliance with Ontario law. You could be looking at something that's from America and not really knowing. So I always caution people that it's better to talk to a lawyer, and just to, even though there is going to be a small upfront cost, I think it's better to have it done properly. And yes, we would be able to provide you with a template.
Well,
With
and
wills.
as you mentioned too, it's an initial cost, right? Like, it's not going
Yes.
to be something that you're going to have to pay for every year. If you've got
No.
a standard contract that you're able to then flesh out or adjust to the circumstances, it gives you a
Exactly.
jumping off point. Yeah.
Exactly.
Okay. Well, thank you both for being here today. It really meant a lot to have you both on the call, and I'm sure that you'll probably get some people reaching out to you, Erica.